Hey guys, so I do a lot of marriage-based green card cases, so if you're interested in that topic, be sure to subscribe because I'm going to be putting out 3 videos on this topic this week alone. A question I've been receiving a lot lately goes something along the lines of this. My fiance is in the US right now on a tourist visa. What's the best option for us to apply for her green card? And the conversation goes into a discussion comparing the pros and cons of applying for adjustment of status in the United States versus consular processing outside of the US in your fiance's home country. Let's look at the pros and cons of both of the different scenarios. And this is a short YouTube video if you want to go really in depth and look at the facts of your specific case and see what's best for you and your family. You could always reach out to me directly. My information is in the video description below. So adjustment of status is when you apply for a green card from within the United States. So if you were going to explore that option, what you should do after your fiance enters the US is generally wait at least 90 days before you take any action whatsoever. You don't want to do anything within the first 90 days that might suggest that your fiance intends to permanently live in the US. And the reason for this is you want to reduce the chances of USCIS determining that your fiance entered with fraudulent intent. The moment someone enters the US as a tourist or student or any other non-immigrant visa status, they must have the intention to depart the United States and not to permanently live in the United States. If you enter as a tourist and then you immediately get married like on day 1 and apply for adjustment of status on day 2, there is a presumption that you had fraudulent intent when you entered the United States. But if you wait till after day 90, the chances of such a determination go down pretty drastically. So let's say in this hypothetical, on day 100 after your fiance enters the United States as a tourist, you get married, right? And then you immediately apply for adjustment of status. What are the pros and cons of that? Well, the main pro is that you guys get to live together and your now spouse will probably get employment authorization 3 months later and a social security card, which will allow you guys to do things such as, get health insurance for your spouse, possibly open a joint bank account. Some banks do require a social security number, get ID, and really beginning to establish your lives together immediately. The major downside, and there are two. One is while the adjustment of status application is pending, which could be a while, it could be anywhere from like 6 months to 18 months, your spouse really should not leave the United States, even if they are granted advance parole, which is a temporary travel document that USCIS will give you. Because even if you have advance parole, when you try to re-enter the US after temporarily traveling outside of the US with advance parole, the Customs and Border Protection officer can exercise their discretion to deny your re-entry. And it's completely discretionary. They don't really need a strong reason to deny your re-entry. So generally speaking, my advice is this. If you have the possibility of an urgent need to leave the United States, like you have an elderly or sick family member and it might end up becoming an emergency during the next year, then apply for the advance parole and pay the extra $630 government filing fee just so you have the option in case it becomes an emergency. But you should not use that, even if you're granted advance parole, to just go on a vacation or to freely travel in and out of the US without a worry in the world, because there is a risk involved every time you travel with it. Now, if you do need to travel outside of the US while your adjustment of status is pending and you do not have advance parole and you actually leave, you've now abandoned your green card process, lose all your filing fees, and you won't be allowed back in as a tourist because you violated the terms and conditions of your tourist visa by applying for adjustment of status. So that would be the nightmare scenario. You definitely don't want that. If there's any chance you're gonna have to leave, apply for advance parole, but just understand there are risks involved with using it. When you get to the end of the adjustment of status process, you and your spouse will both have to jointly appear at a USCIS interview, and I'm actually gonna be doing another video specifically on the interview and how to prepare and what you need to bring to the interview, and another video on processing times and some other information on marriage-based green cards. I'm gonna be releasing both of those this week as well. After you guys attend the interview, typically, if everything went well, 2 to 3 weeks later, you'll get an approval notice, and then shortly after that, the physical green card should arrive in the mail. And once the green card arrives, generally speaking, you can safely travel in and out of the US. There are caveats. There's like a political situation going on right now, so take that with a grain of salt. Watch my other videos on the risks involved with traveling if you're a permanent resident. But generally speaking, 99% of permanent residents, which means people who have green cards, can safely travel in and out of the United States with that green card. Now let's look at the flip situation, consular processing. This is the way that the customs officers want you to apply for your marriage-based green card. So the way this would work if your fiance is in the US as a tourist is you have a couple options. You can get married while you're in the US, but your fiance would need to leave the US, or I guess spouse would need to leave the US within the allotted duration of stay that's permitted by the tourist visa, which is typically 180 days for most people. So let's say your fiance is in the US, you guys get married, now she's your spouse, and she leaves the United States. And by the way, you can do this before your spouse leaves the US as well. So the first step would be to file Form I-130, petition for an alien relative, and you'd be filing that as the US citizen or permanent resident spouse. After that I-130 gets approved, which can easily take like a year or longer, the case will get transferred to the National Visa Center. You have to fill out some more paperwork, pay some more fees, upload some documents, and eventually the case will get transferred to the consulate in the place where your spouse is legally residing, typically their home country. Once it gets to the consulate will reach out to your spouse directly, generally by email, and give them instructions for scheduling an interview, doing a medical examination, and a couple other requirements. Some consulates have specific instructions. Anyway, once your spouse goes to the consulate interview, they'll get a visa in their passport. That's different than the tourist visa. This is actually an immigrant visa, whereas the tourist visa was a non-immigrant visa. So once they get this immigrant visa and they use it to enter the US, the moment they enter the US, they become a permanent resident. They will also have to pay an immigrant visa fee. I believe right now it's like $235. And then the green card will be printed and mailed to you at your US residential address. That process generally takes like 4 months or so before you physically receive the green card, but I expect some processing delays now that we are in a Trump presidency. Now, what are the pros and cons of this consular process? First of all, the moment you file an I-130 family petition for your spouse, it's gonna red flag every time they try to enter the US subsequently with their tourist visa. So technically speaking, one of the benefits of doing it this way is that your spouse will still maintain their tourist visa and will still be able to travel in and out of the United States. However, the customs officers are gonna give them a hard time every time they try to enter, and they can even deny your entry if they believe that the purpose of this entry is to permanently live in the United States. So once you file an I-130 for your spouse, it's very important for, number one, for your spouse to understand they can technically be denied re-entry as they're traveling on a tourist visa while the I-130 is pending. But more importantly, if they really want to travel in and out of the US, they need to bring a substantial amount of evidence to show to the customs officer in the airport or port of entry if they're driving into the United States, to show that they intend to leave the United States and that they're only coming to visit for up to 180 days. Such evidence can include things like evidence that they still have a job in their home country, that they have a home, that they have like a dog, that they have elderly parents or family members for whom they're taking care of. And if you're wondering how to create this evidence, you should schedule a consultation. We can go through the specific facts of your case and create a list of documents that you would need to bring whenever you want to travel in and out of the US with an I-130 pending, because there is risk involved with this scenario. Another major downside is that your spouse will not get the temporary employment authorization or social security number while the case is pending. None of that stuff will apply until they enter the US as a permanent resident, which means they get the visa and they use that visa to enter the US, and at that moment they become a permanent resident. At that point, they'll get a social security number. They'll never get an employment authorization card because they'll just get a green card. They'll skip that step. And the green card, which is the permanent resident card, includes the permission to work, travel, and permanently live in the United States. So you won't need any temporary employment authorization in this scenario. And now the major downside is processing times. This process can easily take 2 years, right? So there's like 3 stages to this process. The first step is the I-130. That can take anywhere from 12 to 18 months right now. You might see a slightly faster processing time depending on which service center receives your case, but I actually expect the processing times to slowly begin creeping upward as the Trump administration begins to gut USCIS resources. Something that the Trump administration can do much more easily is gut the consulate's resources. So the first step would be the I-130. Let's assume that takes a year, which would be pretty good. And it might even take much longer than that. The second step would be the National Visa Center. Average processing times at the National Visa Center is around 3 months. And then the third step is the case will go to the consulate. That means the National Visa Center reviewed your documents, said they generally look good. We call it documentarily qualified. And then they'll transfer the case to the consulate, and the consulate will reach out to you directly. Every consulate has a different processing times. For example, in India, the most recent one I did took around 9 months before the consulate scheduled the interview. So in that scenario, this whole process from start to finish took around 2 years. But right now, the Trump administration is reducing the amount of resources available to the Department of State, which is in charge of these consulates. So a consulate, which may have had 10 immigration officers interviewing people and processing visas so that they can enter the US after marrying US citizens, might be reduced to only 2 employees, which will increase the processing time at the consulate dramatically. So this example I gave where the case was sent to the consulate in India and it took 9 months, that could take 18 months, a year or 2 from now, once the processing times begin increasing as the consular resources get reduced. But there's an even bigger problem, and that is the problem of administrative processing. So sometimes after the interview, your case will fall into a black hole known as the administrative processing black hole to immigration lawyers, where you ask for a case update from the consulate because it's been 9 months or longer than what they said it should take. And their response is your case is being held for administrative processing. This is particularly relevant for the travel ban countries. For example, for some countries such as the travel ban countries, let's take Iran for example. If you're petitioning for a spouse from Iran to come to the United States and your case falls into administrative processing, which is very likely, it might stay that way during the entire duration of the Trump administration. And it's not only until the government changes that your case will continue resuming normally. Now, there might be some options available here. You might be able to sue the government once your case has been pending for an unreasonable amount of time. We don't personally sue USCIS or the consulates at my office, but many immigration attorneys do that. It's an expensive process. It's a huge headache. But my understanding is that you're generally successful when you do that. So anyway, let's take it back to the beginning of the video. When somebody asks me, should I do the adjustment of status because their fiancé is already in the US as a tourist, or should we get married and do the whole thing through the consulate abroad? My general preference is adjustment of status. But there are caveats, and this advice might change tomorrow depending on changes to the Trump's immigration policies. And the main reason I prefer adjustment of status is it's faster, the spouses are together in the United States, so it's not putting additional pressure on the marriage. And it's much more predictable. The processing times are more predictable, the outcomes are more predictable, and it's not just subject to the whims of Donald Trump at the consulates abroad. Yes, it's true that his government can change the adjustment of status process in the US, but you generally have more procedural rights in the US. There is this concept of consular non-reviewability, which makes it difficult to appeal the decision of a consulate abroad. And for anyone who's ever contacted consulates, sometimes they just don't respond. And it's not just you, they do that to attorneys too. So it's just a nightmare to deal with sometimes. And all things equal, right now in April 2025, my personal preference is to do the adjustment of status process. All right, so that about wraps up this video. If you're interested in going through this process yourself, I can assist you. My office handles marriage-based and all family-based green card applications. You can reach out to us. My information is in the video description below. If you're new to my channel, I'm gonna be putting out a few marriage-based green card videos this week. And during the entire 2025 year, I'm gonna be putting out at least 5 videos a week discussing family-based green cards, naturalization, and changes to immigration policies under the Donald Trump administration. If you're interested in these topics, be sure to subscribe, and I'll see you guys next time for another video.